Hi. Shh. Can we start? Can we start now? All right, good. Welcome back, everyone. I hope everyone had a good week so far. Any questions from last class? Any questions on Gruder, Gratz, Adirond, Baki? Yes, ma'am.
So in the few cases where they found that their like process was unconstitutional, does that mean that the person complaining would gain on wins, or that they just have to change their formulation?
Yeah. So the funny part is, Alan Baki was ultimately admitted, but not because of the court decision. He was admitted. They admitted him under the new process, right? So it's not like the court orders the school to admit a person to the program. That would not be the remedy. Good question. Yes, Carissa.
Sort of related to what we were talking about on Tuesday. So apparently Harvard Law is taking.
I saw. Did anyone else see that? Did I tell you this? I tweeted it. My God. Or at least one of you follows me. I'll get to you in a second. Last night, thank you for reminding me. Last night, Harvard Law School announced that they will stop requiring the LSAT for law school. They will accept instead the GRE or none of the above. So here's the rub, right? This is basically a way of applying to law school that standardized testing. Oh. So if you read the article, there's an article in the Times about this exact decision. They were somewhat opaque about why they did this. Allow me to explain a bit. How do I put this? Harvard is not lacking for qualified applicants, right? It's actually number 3 law school. They dropped a peg. They were number 2, now they're number 3. Not that it matters, but they're the number 3 ranked law school in the world, and people around the world want to apply to them. So why are they dropping the LSAT requirement? If you actually read what the dean said, I think it has something to do with indeed diversity, because there's a concern that the LSAT actually limits the number of minority applicants a school can have. Why? Often people are confronted with a choice: study for the GRE or the LSAT. It's an expensive process. You don't have to take both. And there's a concern that by allowing people the GRE, there's a wider pool of people who can be admitted. And perhaps they have different experiences. Maybe engineering students apply. Maybe political science students apply, and other disciplines. So the significance of this is not so much for Harvard. It's the trickle down. So about a year ago, the University of Arizona announced that their law school would stop requiring the LSAT. They almost got their accreditation revoked. The American Bar Association and the AALS went crazy, and they said, we can't let you have this. And they considered throwing them out of the law school market. Ultimately, they relented. But now that Harvard's doing it, this will give serious cover to other law schools that want to stop requiring the LSAT. And there are a couple more advantages of the GRE over the LSAT, as I'm sure you all know as first years. The LSAT is offered, was it 4 or 5 times a year? Right? Now you can? The LSAT, not the GRE. You stole my thunder. That was my next point. But the LSAT is what, 4 or 5 times a year? Yeah, I forgot the exact number. And it's only offered in specific testing locations. So if you miss an exam, it screws up your application process. I think I took mine in November, but you have a few opportunities. The GRE you can take, as Dyer said, 15 seconds early, virtually any time you want, at any testing center, anywhere, I think in the world even. I don't even think it's limited to the US. So the thinking is this will create a bigger pool of not just domestic students, but also international students who can apply to law school. And no more reasoning, no more the quantitative comparisons. It is bringing back awful memories that you had to take for your LSAT. Sergio?
Yeah, I think they were also using the example of business school because a couple years back they started doing that thing. You could take the GRE or the GMAT.
Yeah, and it broadened the scope of people applying. So I think that's largely what's there. And for those of you who follow me on Twitter, it brought to mind Justice Thomas's a dissent in Gruder saying, well, we could just drop the LSAT altogether, right, if it's so important, and find a different means of doing it. So now, indeed, at least Harvard did it. This won't affect all of you, but the next shoe to drop is if other schools follow suit. And not like Harvard, but like schools a little bit lower on the pecking order. will they stop requiring the LSAT and start accepting the GRE? I think we still do. As of today, Derek was still doing the GRE. Yeah, I think we're still stuck with the LSAT for now, but I suspect it's coming soon to a faculty meeting near us, I suppose, right? He's shaking his head. All right. Yeah, Sam.
Well, I'm curious how they're kind of comparing them, because GR and the LSAT, they test, it's like two different ways of thinking, you know? So I'm curious to see how.
So the dean of Harvard said, and this is in the New York Times article, I haven't vouched this, that the LSAT and the GRE are similar predictors of first-year grades. I have no idea to verify that, but Harvard said it, so it must be true. What do they know, right? Who good ever came of Harvard Law School anyway? You know, but the point is, they say it's a good enough predictor. But I suspect the effect of this will be to overall shrink. Now, where this really matters, what this is really going to do is blow up the U.S. News & World Report rankings, right? Why? Because the most important element of those rankings, as we know well, is the LSAT score. And if, let's say, I don't know, 25% of their class doesn't take the LSAT, or 50%, or whatever the number is, how can you possibly compare one to the next? This will be massively disruptive for the rankings. And also, you can't easily compare A to B, right? So if you come in with a 160 LSAT and someone else has a 50 GRE, whatever, right? How do you compare one to the other? I don't know. I'm sure Harvard will figure this out. This is what they call a pilot. They're going to test it out, but they don't launch this thing in the New York Times if it's a temporary thing. They're trying to make a stir. Right? I was in the Journal last night, Bloomberg, New York Times, whatever. All right, other questions? People regretting not waiting a couple of years and taking the GRE alone? Anyone jumping on it? I never took the GRE. Is that a hand? Dyer? Yeah.
I take the GRE. There seems to be more a lot more essay based in the GRE.
Is it?
Yeah.
I never took it. I took the LSAT once many years ago. I've forgotten about it completely. But I don't even remember my score. When I was on my clerkship interview, the judge asked, "What was your LSAT score?" I was like, "I don't remember." I really didn't. But I really didn't. So, but I do suspect this is somewhat tied to diversity efforts. Read Dean Mino's statement. She references like diversity like 4 or 5 times in her statement. So I think this is trying to get as broad of a pool as possible, even for Harvard, indeed, where I don't think they're in any way lacking for qualified applicants. Anything else? No? Okay. So today we're going to be doing 2 cases, and actually it's 3 cases, because Fisher is a 2-parter. I didn't assign the first part, but I'll fill you in on it. These are fairly recent cases. In fact, they were all decided in the last 2 or 3 years. And so much of constitutional law was decided before you were born, right? Even the cases in the 90s, you guys are probably in elementary school. These are cases that are not only recent, but affect the current composition of the court. So they're particularly salient to try to determine how the court will come out in future decisions. All right, so let's review where we were, right? And let's try to trace the arc, if we may, from Bakke all the way to parents involved. And that was a roughly 28, 29-year stretch. So Bakke was the first major decision of the court to consider affirmative action. And as you may recall, there was not a single 5-vote majority one way or the other. 4 justices, including Justices Brennan, Blackmun, Marshall, and White, held that race-based preferences, when they're for the benefit of an ethnic minority, are desirable and are not subject to any sort of strict scrutiny. And that the rationale for these race-conscious measures was remedying past discrimination and leveling the playing field and bringing people up to the starting line, so to speak. That position has never gotten 5 votes. I appreciated many of your comments about this topic last week, and you expressed your thoughts. One way or the other, courts never quite embraced that. The one vote in Bakke that actually mattered was Powell. Powell said that the only compelling interest with which affirmative action can be justified were the benefits that flow from a diverse student body, the educational benefits from diversity. Not diversity by itself, because that's merely racial balancing. That would not be adequate. But the benefits that flow from diversity in an educational setting, that can justify the use of strict scrutiny. but only if it's narrowly tailored. The program at UC Davis, Powell wrote, was not narrowly tailored because it was a straight up quota, and that amounts to racial balancing. As we discussed today, discussions of a critical mass, and when you achieve it, keep in mind Powell's discussion of racial balancing. Okay, but then we move forward in the 80s and the 90s. The court split one way or the next all over the place until finally we get to Adirond. And in that case, 5 justices held that even for the federal government to use race-based classifications, it must satisfy strict scrutiny. And the bonus in that case given to minority contractors, that is, contract businesses owned by minorities, was unconstitutional. But then we get to the 2003 case of Grutter and Gratz. These are from the University of Michigan. Again, in 5-4 decisions, Justice O'Connor wrote for the court in Grutter that the Michigan Law School's program was acceptable under strict scrutiny. Why? But was pursuing a compelling interest. The benefits that flow from diversity. She got that from Powell and Bakke. Was it narrowly tailored? She said yes, because it was a holistic review, which considered lots of different factors, where race was a factor of a factor of a factor. Yet the court in the same very day invalidated the program from the Michigan undergraduate in Gratz, which is described as mechanical, because it set aside a number of points on the admission scale merely because of an applicant's race. And in many cases, that factor, 20 points out of 200, was outcome determinative. That is, that one factor, that one check, would more or less decide if a person get in or a person was rejected. Keep in mind that Justice Kennedy dissented in Grutter. Justice Kennedy did not go along with Justice O'Connor. Right? At the time, Justice O'Connor and Justice Kennedy, both Republican appointees to the court, were considered swing one way or the other. In this case, Kennedy dissented. But then a couple years later, we move on to Parents Involved, which considered the application of affirmative action in the context of primary schools, elementary, secondary, high school schools. And in that case, the court held that the Louisville and the Seattle programs were unconstitutional. But again, there was not a solid 5-vote block for why. Chief Justice Roberts, writing for 4, held that affirmative action can never be used in the context of lower education. And he wrote in a passage we'll be discussing today that the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. Justice Sotomayor took that off in her Schuette dissent. Roberts also held that you can never have a compelling interest for diversity in the context of lower education, where everyone's coming from the same geographic area, more or less, and this idea of broad diversity, he said, didn't work. Justice Kennedy disagreed. He concurred in judgment. Justice Kennedy held that diversity could be a compelling interest for undergraduates, but the Louisville program failed. Why? Because it was not narrowly tailored. Because there were other race-neutral means by which they could achieve that goal. Changing zoning around, recruitment, listed a bunch of them. So for Kennedy, strict scrutiny required that they use the most narrowly tailored means. And if there was some other race-conscious measure to achieve the goal, and they didn't do that, then their desired approach was unconstitutional. They couldn't choose the second best approach. They had to choose the best approach. There wasn't that much deference. Okay? Everyone with me, right? Questions on that? That gets you, what was it, 2005, 2006, whenever Parents Involved was decided. I think it was 2006. I think it was a 1L that year. 2006. But then we have the 3 cases for today, which are like the next major components of the court's affirmative action jurisprudence. We have, and it's pronounced Schuette, right? Schuette, Rhymes with duty. Don't laugh. But the Attorney General of Michigan, his Twitter handle is actually Shooty on duty. So you're sick. It's the other one, not that duty. But it's pronounced Shooty, and the name of the case is a long one. I shorten it in the summary, but it's the Coalition to Defend Affirmative Action, Integration, and Immigrant Rights, and Fight for Equality by Any Means Necessary. And that phrase, by any means necessary, you may have heard it among Sartre, but among others, but also Malcolm X. So it's a very specific historical phrase they're trying to evoke. Okay, and then we'll do Fisher 1 and Fisher 2. I didn't assign you Fisher 1 because it's more or less obviated. We'll work it into the discussion. All right, any questions so far? All right, what did I finish last time? You're up or she up? You're up. All right, Michelle, do you have the facts, please, in Shooty, please?
The Michigan voters voted
Yep, Prop 2, very good. Proposition, not proposal. Yeah, but you're good.
And that race-based preferences cannot be part of the admissions process.
Only race and everything else, pretty much, right? Okay, so I have a personal history with this case. I was clerking on the Sixth Circuit when this was decided at the circuit level. So the judge I clerked for was one of the people ultimately participating in this case. So I am intimately familiar with it. So here is what happened. Here's the history. Following the Supreme Court's decision in Grutter, there was a very vigorous effort by a couple people, one of which was Jennifer Gratz, who was actually the namesake of the case, and Ward Connolly, who was another advocate. And they launched a statewide effort to amend the Michigan Constitution to prohibit the use of race, sex, color, ethnicity, national origin in admission decisions for state colleges, and really for all arms of state government. It actually wasn't just limited to education, although that's what people think of it. It included public employment and public contracting as well. Okay. So before we get to the actual amendments, Samantha, in Michigan, what was the traditional fashion by which educational policies could be altered, such as admission decisions? How would this be done traditionally before this amendment took over? Very good. So in Michigan, unlike in Texas, they have 3 primary state universities. Well, I guess it's similar to Texas, but a little different structure. So there's University of Michigan, there's Michigan State, and there's also Wayne State. Those are the 3 big colleges. And the members of those board are indeed elected, right? So Samantha, I'll come to you again. If Jennifer Gratz and other people wanted the school to change their affirmative action policy, how could they have accomplished this absent the amendment? Right, okay, good. So as elected officials, they had a couple options. They could have voted, they could have lobbied the members of the board saying, hey, change your admission policy. And if they didn't vote this way, they could have thrown the bums out of office, right? I forget how many years the terms were, but 4 years, whatever the term is, right? So it might take 4 or 5 years till everyone's term expires, but eventually, if enough political pressures applied, they could throw these people out of office and elect in those who can change the policy. And again, there were 3 universities, so I think it's probably 5 or 6 people per board. So we're talking maybe 15 or 16 officials you'd have to vote out of office, right? Chandra, would there have been anything unconstitutional? Would there be any problem whatsoever if the 5 members of those boards on their own initiative said we're going to drop our affirmative action? Would there be anything problematic about that? Why not?
Unconstitutional?
Yeah, well, would the 14th Amendment even be implicated if the 5 members of the Michigan University Board said we're going to drop race in our admission protocol? Would there be anything unconstitutional like that?
No, because I don't think know if there's been stretched that far.
Does the Constitution require the use of affirmative action?
No, it doesn't.
Okay, that's the exact right point, right? And actually, Justice Sotomayor makes this point in her dissent. The 14th Amendment doesn't mandate the use of affirmative action, right? And indeed, in Bakke, in Parents Involved, in Grutter, right? Affirmative action kind of skated by the skin of its teeth, right? It like was upheld, but like barely, right? It was upheld like, well, if you get everything just right and you line up just right. So there's no argument that affirmative action is compelled by the Constitution. So if Gratz and others had actually elected 15 members, I don't know the number, whatever it is, 15 new members to the board, and they voted for this policy, then they could have modified it to eliminate race, right? So that's one path. I think everyone agrees, even the majority in dissent, that such a path would have been perfectly lawful, no problem whatsoever. All right, Gladys. Instead of lobbying or probably electing new members of the board, what did the advocates of Prop 2 do? Okay, and what was the effect of that amendment? Well, the people of Michigan voted for the amendment. It has to have like a state, the same way voting tax is a statewide vote. But what was the effect of the amendment?
It was to basically ban race-based admission, the race-based admission process.
Let me ask the question more precisely. After this amendment was passed, did the 5 members of these boards have the discretion concerning the implementation of affirmative action policy?
No.
Okay, good. What was the exact effect of the amendment then?
It basically took their authority away.
Okay, and this is the important part to understand about this amendment, right? It didn't merely change the law, which it did in Michigan. It specifically said no state official, and I mean read the read Section 3. It applies to every government instrumentality in Michigan, which means these 5-member board. Every state official is now prohibited in implementing a race-based program in any of their decisions, whether it's education or public employment or government contracting, right? So now, Alexa, let me ask you this question. What happens if there was a group, and the name of the group is BAMN, just calling it short, BAM, that's how they pronounce it. What if BAM then wanted to change this policy? Could they lobby the 5 members of this board to reverse their policy and reinstitute a race-based affirmative action program? Why not? So what would BAM have to accomplish in order to change admission policies at Michigan University? What would they have to actually do? How do you change that? Yeah, you would need another statewide referendum. In other words, the only way to remove this provision from the Constitution of Michigan is to enact a second amendment to the Constitution, not the Second Amendment, but a subsequent amendment to the Constitution that nullifies Prop 2. Everyone with me, right? So the primary effect of Prop 2 was to change the manner in which decisions were made within Michigan. Now the only way to actually change this policy going forward was to literally have another statewide referendum. And I think the book edited this out, but it's not easy. You need to collect like thousands of signatures, and you have to have a very elaborate statewide campaign. And then you have to advertise in commercials, vote yes on 2 and vote no on 2, whatever it is. So it's a fairly robust process to accomplish this. It can't be done overnight. And it might take years to get this back on the ballot. And in the interim, the Michigan schools are prohibited from using and considering race in this fashion. Okay, so everyone understand the gist, right? Any questions on this? Nico? Go for it.
So you said the only way they could change this is by having another referendum, or just invalidate that constitutional.
By going to court.
Right.
And that's what they did, right? Thank you. Thank you. I like it. Favorite. Right? So that's exactly what they did. So this group, the BAM, right? They went to court and they argued that this was unconstitutional, right? Now, a minute ago, Cullen, I asked Chandra, I said, is there anything in the Constitution that requires affirmative action? She said no. And she's right about that, right? So what could possibly be unconstitutional? What could possibly be unconstitutional, right, about this if there's no requirement to have affirmative action based on race?
The argument was that by not allowing a law that opens up doors for certain groups, that it's discriminatory towards those certain one.
You gotta be more precise than that. What about Prop 2 was unconstitutional? What exactly did BAM argue?
That it made it more difficult for those groups to affect the laws.
Good.
And the decisions.
Okay. So I think Colin stated it quite well. BAM argued that this Prop 2 made it more difficult for minority groups to lobby for change, in this case based on affirmative action, right? What do we call this doctrine, Pablo? What's this doctrine called? It's mentioned in a couple of cases that are referenced.
What doctrine?
What's the doctrine that Colin just articulated? What's it called? What's the name for it? 2 words. Yes, thank you. What is the political process doctrine? Tell me what that is. Shefa, what's the political process doctrine? This is the crux of the entire case here. I'm sorry, louder?
It's based on the key purpose of the
What is that key purpose? Yeah, you're not giving it. You're not giving it. Stephanie? What? I mean, this is the entire crux of the case. What is the political process doctrine? I can't hear you at all. Rena? You gotta speak louder. I can't hear you. Altering procedures of government. What do you mean by that? Elaborate more. You're on the right track. Cameron, want to give it a shot? Okay, that's really close, right? Yeah.
They're basically saying that they're taking the power away from those elected officials for the school boards that were more easily voted on by the minority groups, and now they're transferring it to.
Really, one more bit. Well, that was a holding this case, but I saw it. Lauren or Josh, you guys are really close, really close.
the voting process determines who makes the laws, and therefore if you don't have equal access to the voting process, then the laws themselves cannot be influenced. If they're not representative in the legislatures, the people that are making the laws.
There's one really important attribute of this. That's
Well,
not quite.
It's discouraging minorities from taking ability to take position in the political process because Justice Sotomayor says he can't even convince the Michigan schools.
Okay, that's right. But what's the key point? Why did this change? Right? What about this rule? What about the rule made this effect? You're really close.
What was the question again?
What aspect of Prop 2 caused this effect? You guys are really close. What exactly did Prop 2 do with respect to the system that was already in place?
Well, it took the power away.
Ah. Okay. First one, fix that.
Well, Mr. Mayor says that the alteration triggers like a strict judicial.
At what point did the alteration occur, according to Sotomayor? This is what I'm looking for.
It's when the political process in a manner burdensomely racial.
Yes, but Brian.
Is it when one process is more burdensome?
Yes. Okay. The rules change in the middle of the game, right? That's what I was looking for. You were all like hovering around it. But the key point about the political process doctrine is that there was one process in place that yielded some policy that benefited racial minorities. And then in the middle of the game, the rules were changed such that a different process would be needed to restore that same policy, right? In other words, this affirmative action policy was instituted by this 5-member board, right? Policy A. This amendment was passed. To get that same policy A back, you got to do something even harder. In this case, amend the Constitution instead of throwing, those 5 members out of office. Everyone sees that you're all right, but the key point is in the middle of the road, the rules are shifted. So to achieve the exact same outcome, you need to go through a much more significant and elaborate process. Everyone get that, right? That's the crux of this doctrine, right? It's not just that some local board adopted a policy that was unfavorable to minorities, or the voters enacted a policy that harmed certain minorities. That's not it by itself. It's a very specific aspect of making it harder to undo it, right? Control Z, right? It's harder to undo that change now because of this alteration in the political process. Everyone with me? Right? This notion of the political process derives from a case you'll study in 2 or 3 weeks called United States versus Caroline Products. The facts of the case are actually far less important than what it came to stood for. The case involved whether, I mentioned this with the Filled Milk Act, right? I mentioned this, right? Whether a person who sold filled milk, right? Remember they take the dairy out and they put the vegetable oil into the milk. Whether Congress could criminalize that, right? Whether making milk was engaging in interstate commerce. And remember, this guy would not ship it across state lines, where he kept it within his own state. But in the opinion in Caroline Products, there was a footnote, probably the most famous footnote in the history of the Supreme Court. It's known as footnote 4. It is so famous, if you ask anyone, footnote 4, they'll know what you're talking about. No one even knows the name of the case where it's from, right? Or what the case was about. It was a good case. But the most famous aspect of this is footnote 4 of Caroline Products. And footnote 4 by Justice Stone tried to articulate a theory of constitutional law that was very influential. This was one of the first stabs at articulating when courts will apply heightened or strict scrutiny. And what the court said was, if some law, right, some law affects a provision of the Bill of Rights, such as free speech, you apply strict scrutiny. So if some law restricts free speech, you apply this very strict scrutiny. Or if the law affects what were called fundamental rights, which we'll study next week, if the law affects fundamental rights, you give it strict scrutiny. This was the basis of the right to privacy, abortion, and other sorts of things. An aspect of Stone's footnote 4, which said, even if even if some law doesn't touch on a provision of the Bill of Rights, if it affects, and here's the magic phrase, discrete and insular minorities. Right, that's the magic phrase. If some law affects discrete and insular minorities, there is a role for the courts to apply heightened review. Now, what does discrete and insular mean? It doesn't just mean straight up minorities, right? It's not just saying ethnic or racial minorities. Insular means separate, right? What does it mean to insulate, right? You separate something, right? Insular means people who are not connected to the political process, who by whatever means they can't change things by voting or can't change things by lobbying or whatever else the situation happens to be. Justice Stone wrote that under this footnote 4 paradigm, the so-called discrete and insular minorities are given heightened scrutiny when a law touches on them. And this gave birth to an entire theory of constitutional law known as process theory, right? That courts are there to reinforce the process or reinforce the representation of these discrete minorities where the political process will not, right? The phrase political process doctrine, I was beating Cullen on a minute ago, right? It came from this, right? Where the political process is broken down, so to speak, and the minorities cannot reinforce their own representation in the elected branches, this is the opportunity where judicial intervention intervenes and provides heightened review to give whatever additional benefits are possible. Okay, everyone with me? Right? Cameron, yes, ma'am.
Who decides?
Oh, what a beautiful question. Who do you think decides? Yeah, I think that's the answer to all the questions. But yeah, basically the court applies without much guiding who is discrete and insular.
I think about the voter registration idea, like.
Oh yeah, yeah. That comes up. Did you finish reading the decision?
No.
Okay, well I didn't sign it. He asked me to read it. So if you actually read the voter ID opinion, I promise you this will be cited somewhere in it. I'll bet you $5. I'm pretty sure this is cited somewhere in it. Check me on that later, but I'm 90% sure I'm right. Cited. I once did the math of an article on like 90-something times for the Supreme Court in various contexts to say whether the minorities were outside the political process, a heightened degree of judicial scrutiny is warranted. So Jason or Cameron, check me on that later. I'm pretty sure I'm right.
I'm checking right now.
Yeah, yes, ma'am. Yes. Right, and specifically though with voter ID, there's a statute at issue, right? And the statute is the Voting Rights Act. So you don't exactly even need footnote 4. Footnote 4 is for a straight up 14th Amendment claim. So the voting ID stuff is not brought under the 14th Amendment. There is 14th Amendment stuff in there, but it's primarily a statutory claim. So it's more cited for atmospheric, but this footnote 4 is primarily when you do with a straight up 14th Amendment claim, right? For example, in this case, the Michigan case, there's no allegation that it broke a statute, right? The allegation was it violated the 14th Amendment straight up.
But left didn't find anything.
Oh, well, I'm wrong. But thank you. But which is probably the reason I gave to Cameron as a statutory case. But this, I wrote an article once in footnote 4. I think it's been cited like 90 odd times. Like it keeps getting cited over and over again by the court. Right. So this theory, this process theory, was very influential. And if you notice, I just said was. It's been on the wane, so to speak. It's been on the decline. 2 cases where it was used in a fairly robust manner. The first was 1969, Hunter v. Erickson. And the second was 1982, Washington versus Seattle School District number 1. Don't confuse this with Parents Involved versus Seattle School District. They're different cases. The fact they're both from Seattle is purely coincidental. Zishan, what was the situation in Hunter, please? Hunter v. Erickson, 1969. Did you read the case? Not complete, so you didn't read it. Okay. Chris, what was Hunter? Did you read the case? It wasn't. It was mentioned within Schuette. Cameron, did you read? What's Hunter?
This is a case where the city passed an ordinance which would affect the rights of the minorities.
And what kind of ordinance was it in Hunter?
It was about about housing.
Exactly. Yeah. So the city council enacted a fair housing ordinance. What happened next, Cameron?
So what they wanted was they came up with a provision that impact on a significant scale, it should be not done in normal course of action. It should be taken to a higher level.
Exactly right. Okay. And by the way, I don't know. I think there's a sentiment among law students. If it's not in the textbook, if it's in the supplement, you don't read it. Don't do that. Read the cases. But Cameron's exactly right. This case involved a situation where the city council I think it was in Akron, Ohio, that provided causes of action for racial discrimination in housing. Amended the city charter, and they said that any sort of anti-discrimination ordinance must be approved not by the members of the county, by the city council, but by voter referendum. So what was effectively happening was, before this rule, the members of the city council were able to prohibit discrimination. After this rule, they were not allowed to. The only way to achieve such a goal was through the voter referendum process. Okay. Now, I didn't assign Hunter. If you want, you're welcome to go read it. It was somewhat of how do I put this? A classic Warren Court case, heavy on passion and low on law. So it wasn't exactly clear the basis in which the decision was raised. And if you can tell, the majority opinion was like, we're not quite going to overrule it, but like we don't really agree with it. That was the general sentiment. And the court read it very narrowly. The court said that Hunter rests on the unremarkable principle that the state may not alter the procedures of government to target racial minorities. That wasn't what Hunter held. If you go read Hunter, it was pretty full-throated defense of the political process doctrine. And it said in no uncertain terms that changing the process to harm minorities is subject to strict scrutiny. The court ran away from that pretty quick. They didn't quite overrule it. In fact, if you notice the vote breakdown, there are only 3 votes in the majority. Scalia and Thomas would have dissented over, not dissented, but they overruled Hunter and Seattle, and Justice Kagan have recused. So there wasn't actually there wasn't actually a 5-vote block here, but there were 5 votes enough to uphold the Michigan Amendment. By the way, one note, I mentioned I was clerking when this case was decided. The en banc court, those of you who don't know what en banc means, you usually start at the Federal Courts of Appeals with a 3-judge panel. The 3-judge panel is divided 2 and 1. Then the state of Michigan asked for the entire 6th Circuit to rehear the case. I think there were 15 judges sitting on the case. The case split 8-7, all the Republican-appointed judges in the minority and all the Democrat-appointed judges in the majority. But the thing that people don't remember at this case was that there were 2 additional Republican-appointed judges who recused. Why? One taught at UM, and the other taught at Michigan State. Had they been on the case, I'm almost certain that the circuit decision would have gone the other way. But it was a very, very divided court. The 6th Circuit, where I clerked, was, a debate. Is the 9th Circuit the most overturned? In recent years, there's actually the 6th Circuit, which is Ohio, Tennessee, Michigan, Kentucky. That court has basically declared an open defiance to the Supreme Court on death penalty cases. They just ignore it, and they get reversed very frequently. So the 9th Circuit is not the most recently overturned court, but is indeed the 6th. All right, so that's Hunter, okay? Kimberly, what was the Seattle school case? It was decided, was it 1982, so 13 years later. Okay.
alleviate racial isolation of minority students. And then voters that oppose the program passed the state initiative that barred the busing desegregation.
Okay. So Seattle, the facts were like this. School board adopted a policy to incorporate busing. We don't study the busing cases anymore, but these were really big deal in the 70s and the 80s, where to minimize what they describe as racial isolation, they would bus certain minority students to predominantly white schools and the other way around. These were very unpopular policies, very unpopular policies. And what actually happened here was that after the school board made this decision, there was a statewide referendum, not too dissimilar to what happened in Schuette, in which they said that the school board basically now lacks the power to integrate through the busing program. They lack that power. So again, before this referendum, the school board could institute a busing program. And after this referendum, they could not institute a busing program. The court in Seattle struck this down, and very broad language. Again, the court here is like tamping down on it, but this was a Harry Blackman opinion from 1983. This is like peak Blackman, no relation. This was a 5-4 decision also. This wasn't 9-0. This is a 5-4 decision, very sharply divided. And the Seattle court stated that where government policy, here busing, is to the benefit of minorities, then a state action that places decision-making over that policy at a different level must be reviewed at strict scrutiny. What does that mean? If there was some sort of policy that benefited minorities and the state made it harder to bring that policy back, courts would review it under a strict scrutiny review. And as you know, if it's something is a strict scrutiny review, the courts are not likely to uphold it. Okay? The Court of Appeals, the Sixth Circuit, where I was clerking at the time, ran with this. They said, this is unconstitutional, right? This is Seattle. Me, Josh. So when I was clerking there, I wrote a memo, which was ultimately discarded, but I said, I don't think Seattle's good law anymore. I actually wrote an article about this subsequently, but the Supreme Court had never cited the Seattle case. And there were a number of cases where they should have cited it, and they didn't. And Justice Kennedy never cited the Seattle case. So I wrote a memo saying, Judge, I predict that Seattle will be overruled. I was right, but anyway, it was merely in dissent. But the outcome here is the court says, this reading must be rejected. That means overturning it, but not quite. The expansive reading of Seattle has no principled limitation and raises serious questions of compatibility with the court's settled equal protection jurisprudence, which is precisely the point I made in my memo back in 2011 or so, whatever it was, that cases that can't be squared away with Seattle. Right? And I think the reason why Justice Kennedy was so passionate about this was that he was afraid that this regime would get in the way of the democratic process. And even Justice Breyer, who's no right-winger, concurs with the majority because he feels strongly about the democratic process. And he doesn't want courts intervening to stop the people from making these sorts of decisions. As a side note, this case was what, 2013 or 2014? This was decided shortly before the same-sex marriage decisions. And there was a brief glimmer of hope for those challenging the same or defending the same-sex marriage laws, that this meant that Justice Kennedy would be in favor of voter referendums for banning same-sex marriage, right? Read this beautiful thing that people can decide for themselves, and maybe it's not the best decision. So people thought, wow, maybe this means Kennedy will uphold the marriage laws. Not so fast. That didn't last, but there was this brief glimmer of hope. So Kennedy's opinion says it's demeaning to the democratic process to presume that voters are not capable of deciding an issue of sensitivity. And to the extent that Hunter and Seattle see otherwise, those cases are overruled. So this case is not really an affirmative action case, although if you read the dissent, it becomes one. But the majority opinion is all about political process and about the democratic ability to modify your own laws. Okay. Any questions in the majority by Justice Kennedy? And again, it was only for 3 votes. Only the Chief and Alito joined it. So it's one of these weird situations where, was Hunter and Seattle actually overruled? Kind of. Not really. Probably. Unlikely to be cited again. Because only 2 justices seem content on relying on them. Anything on the majority? Let's do now the let's do Justice Breyer first. We'll come back to Scalia in a second. I'm gonna take the various opinions out of order because it'll make more sense this way. Right? Oh, you're not in this class. John, what I almost called Professor Finch. That would have been bad. John, what was the what was Justice Breyer's point in his concurring opinion? No. In Schuette, what did Breyer say?
Oh, I'm not sorry.
Right. Okay. Breyer's opinion was actually fairly technical, and this is like the most. This is like peak Breyer, and allow me just to walk through this Breyer patch with you, if I may. A couple of you got that. In Michigan, it was certainly true that the members of these boards could decide to use affirmative action policy, but it's a matter of reality. Who actually made the decisions? Professors, administrators, right? These low-level unelected officials. In Breyer's mind, there was not actually a shift of power from one group to another. He says that the school boards, not the school boards, these trustee boards never actually authorized the use of race. So in Breyer's very uber technical, uber literal reading, there was no shifting of authority. This was actually a fairly significant issue in the lower courts. This came up a lot, and Justice Kennedy doesn't even. But the 5-member boards had never actually decided this issue. It had been delegated down to the university administrators, which is something of a dodge, right? But Breyer loves democracy. That's what, when he wakes up in the morning, he says, "I love democracy," and it would have been very hard for him to rule in this case against a ballot measure that got 58%. Okay, any question on Breyer? Yeah, but this is like peak Breyer, an uber literal interpretation that lets him reach the Democratic result. This is like, he must have had a really good, rush with this one. Let's go on to Scalia. Scalia begins. I'll call you in a second, Jenna. Scalia begins. God. It has come to this. Called upon to explore the jurisprudential twilight zone between 2 errant lines of precedent, we confront a frighteningly bizarre question. Does the Equal Protection Clause of the 14th Amendment forbid what its text plainly requires? Jenna, what is he getting at there? What is Nino talking about?
He says it's facially neutral.
Whoa. How did Scalia vote in Grutter? Let's go back to last class. How did Scalia vote with Thomas and Grutter? How did Scalia and Thomas vote? How do you think Scalia voted in Grutter? You can guess. It's not that hard. Did Scalia or Thomas think that race-based affirmative action was ever justified? Right. So what's he getting at here when he says, does the Equal Protection Clause of the 14th Amendment forbid what its text plainly requires? According to Scalia, what does the text require? It's on your notes. On your notes. Carly? What does Scalia think the text requires of the 14th Amendment? It's not in your notes. Up here. What does Scalia think the text of the 14th Amendment requires? It's not in your notes. I don't want your computer. What does Scalia think the text of the 14th Amendment requires? Steve?
Well, it has to afford all persons equal protection of
Does, in Scalia's mind, the 14th Amendment permit any racial classification?
No.
No. Right? Scalia's like this. Affirmative action is unconstitutional, period. So how could it be that getting rid of it's unconstitutional? Right? That's his point. Scalia says affirmative action is barely constitutional in the first place. How could it be that getting rid of it is itself unconstitutional? Steve.
I feel like we went a little overboard.
Yeah, he usually does in dissent.
It sounds like whatever they cook up in trial, you know what? Like, as long as it's facially neutral, I mean, there can't be no discrimination.
Right.
I
Well,
disagree because I think you gotta look at the numbers.
which numbers?
I'm talking about Fisher case.
Yeah, and I thought you were. Okay, we'll get to Scalia and Fisher in a little bit. Okay, I promise. Well, actually, he wasn't live for Fisher 2, but he was there for Fisher 1. He sure was. But yeah, I thought you were asking Fisher. But Scalia's point is, if affirmative action is barely constitutional, if at all, how can it be that it's unconstitutional to now take steps to prohibit it? Right? He would have overruled in its entirety Hunter and Seattle. And he quotes from Justice Harlan and Plessy, this quote, which is, again, not universally accepted nowadays, that our Constitution is colorblind and neither knows nor tolerates classes among citizens. The people of Michigan, Scalia writes, wish the same as Harlan saw it 100-some years ago. Okay, everyone with me? All right, so any questions in the Scalia concurring opinion? It's basically dissent, but not really. He rejects the entirety of the majority's opinion. He would just get rid of the political process doctrine, period, as a fabrication of the Warren Court. Questions on Scalia and Thomas? All right, let's go back to you, Carly. Walk me through Justice Sotomayor's dissent, joined by Justice Ginsburg. What was her primary what was her primary purpose in that dissent?
She pretty much said that they weren't on the political process doctrine properly, and so that was leading to the first said there needs to be acts made by the court so the legislator does not oppress minority groups. And pretty much was saying she was that doctrine and was fine.
Okay. So the first major difference between the majority and Justice Sotomayor in dissent is the dissent's okay with Hunter and Seattle. In fact, she would keep them. And she says that the majority failed to abide by stare decisis and didn't give adequate justification for reversing those precedents. And she says that under Seattle and under Hunter, this is a situation where beforehand, admission decisions were in the hands of these boards. And after that, they were now in the hands of the constitutional referendum process. And that significant barriers were placed for changing this. And she makes a point that I think was actually fairly effective. She says, well, what happens if people want to lobby UM to admit more alumni, the legacy, right? They can just go and lobby, they can vote, they can, run commercials. What if they wanted to say admit more athletes, right, to Michigan State? Same thing, they could lobby, they can vote, whatever. But if they wanted to say, let's use racial classifications, then they'd have to go through a hoop. They'd have to go through the referendum process. And I think that if Hunter and Seattle were still good law, I think Sotomayor was probably right. This is probably unconstitutional. The problem is those cases were somewhat of an anomalous, and they were never quite relied on. So the court didn't have much problem discarding them. But if Seattle was actually still good law, it was a 5-4 decision from 35 years ago, she's probably right. But those cases the court basically discarded. But the most significant aspect of her dissent, the one that I think had the most impact on the court itself, was her discussion of the Chief Justice. Everyone knows what I'm talking about, right? So we read last week, or last class, in the Parents Involved case, the Chief wrote that the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. She calls the Chief, quote, out of touch with reality. Whoa, right? I mean, whether you agree with her or not, that's like a Scalia line, right? That's not the normal collegial line that you put in a Supreme Court opinion. And Roberts, we'll get to his opinion in a minute, took offense, and he actually wrote in response to her. And I usually criticize the chief, but I'll give him a compliment here. He's usually very restrained and doesn't take the bait on these issues, but he went right back at her. So this was definitely something personal. The second thing that I want you to appreciate is in Fisher 1, and this is on pretty good intelligence, the outcome of Fisher 1 was weird. Okay, what happened in Fisher 1? The Supreme Court was considering whether the Fifth Circuit applied strict scrutiny to UT's admission policy. The case was argued, I think, in the first week in October, and it floated around for the entire term, floating around, no decision. And then finally, at the very end of the term, in a 7-1 decision, the court reversed, but in very narrow ground. They said, we're reversing because you didn't apply strict scrutiny, go apply strict scrutiny. And there was no dissent there from Justice Sotomayor. Ginsburg dissented solo. We'll talk about that in a minute. But Sotomayor did not dissent. Here's the inside baseball, and this is from Joan Biskupic, who wrote a really good book on Justice Sotomayor. I encourage you to read it. She said that the dissent in Schuette that you're reading now was actually Sotomayor's dissent in Fisher 1. Whoa. She wrote that Sotomayor circulated this dissent in Fisher 1, and apparently it persuaded Kennedy not to strike down the affirmative action policy. Ginsburg basically acknowledged that was the case in some interview. She talks way too much. But she said something about Schuette. Yeah, Sonia regretted the Fisher decision, so she put her thing in there. Right? She basically hinted at it, right? So the dissent you have here in Schuette was, in fact, a draft dissent from Fisher 1. So as Taylor would say, there was bad blood here, right? This was from the past. And she incorporated an opinion where it didn't really fit, right? It wasn't about affirmative action straight up. So she basically recycled her own dissent. And the chief got back at, probably what was going on there. But this teaches a number of lessons. And people ask me at this, do justices change their votes? All the time. And not just if they're named Roberts. That's Obamacare, right? They change their votes. And here, I think the papers will affirm this in 50 years when I read them, but Justice Kennedy probably changed his vote on the Fisher 1 case and to remand it. And here's to give it one more. The decision to kick it forward a couple of years meant Scalia was not alive when it came back. Had Scalia been alive with Kagan recused, Fisher would have won 4-4 with no decision, which would have affirmed the UT policy. But the decision to put this down the road a couple of years meant the court flipped and ruled that the UT policy was valid. So there's so many moving parts in the Supreme Court that you never actually see. And here we have a little glimpse based on people who talk to reporters, and they know this stuff. So the Sotomayor dissent here was, in truth, her dissent from Fisher 1 that was never published there.
Just to clarify, what is Scalia alive for all arguments?
Yes! Oh, such a good question. I was going to get there later, but I'll do it now. Nino was there for arguments in Fisher 2. He died before it was decided. It was argued, I think, the first or second week in October. Had they published that decision in January, it would have been a done deal. Fisher would have lost, and Fisher would have won. The fact that they published it later meant that the initial vote was canceled and had to revote. Because after Scalia died, there were a number of cases they had to revote on. And that's how this Fisher 2 is a 4-3 decision. What is the value of a 4-3 decision? Ugh. It's something that people like me like to argue about, but it's not clear. It's probably good enough because were Kagan there, she probably would have voted with the majority, so it's probably 5-3. And in fact, Justice Ginsburg, in an interview, let me get this quote. It's too bad. Oh God, where is it? In an interview, Justice Ginsburg basically said that Justice Kagan would have voted with us anyway. That was utterly inappropriate. But she says lots of things she shouldn't say. It's good to give information. I think it's utterly inappropriate, but she gives lots of information. Curran.
Why did they have to revote on decisions when Scalia died?
Because he was a 5th vote.
But it wouldn't stand even though.
If you're dead, you can't sign an opinion.
Right, but if I thought you meant decisions that were made before he died.
Until the opinion's published, it doesn't count. The votes are internal, and the votes are internal, but not released. So if Scalia was the 5th, okay, a second. If Scalia was the 5th vote, once he dies, you got to go. Had the opinion been issued like a week earlier before he died, it'd be a done deal. In fact, one of the last decisions Justice Scalia made, one of the very last decisions Justice Scalia made, was to issue a stay in the Clean Power Plan litigation. This was the climate change thing, right? One of the very last official acts he did was to put a hold on the Obama-era climate change regulations. He died like a week later. Actually, the last thing he did, this is even stupid, he approved a request to add the number of pages to a brief, right? It's the most mundane thing. His actually last act I checked was there was someone said, we have more words in our briefs. Like, yeah, you can have them. And let me give you that Kagan quote. I got my notes up here. I'll get you a second, Michelle. Justice Ginsburg said, here we go. If Justice Kagan had been there, it would have been 5-3. That's about as solid as you can get. She added, I don't expect we're going to see another affirmative action case, at least in education. So, from the horse's mouth. And Michelle? Oh, good question. So, Elena Kagan was the Solicitor General. The thinking is at some point she advised the Obama administration on whether they should file a brief in the lower court decision in Schuette. But the justices do not give a reason for the refusal. We have to guess. It's a fun pastime, right? So almost certainly the reason why is at some point she advised something. Now, here's the big thing with Kagan. Why did she not recuse on the Obamacare case? This is actually in my book, if you want to read it. I have a chapter on this. But Obamacare was signed into law on March 23rd, 2010. Not that I know the date by heart. At the time, Kagan was the Solicitor General. And lawsuits were filed that day. Lawsuits were filed that day, March 23rd, 2010, in Florida, Virginia, and elsewhere. The day before it was signed, her deputy, a guy by the name of Neil Katyal, emailed her and said, hey, Elena, do you want to come to this meeting with the White House to talk about defending the ACA? And what was Kagan's response? What's your phone number? What's your phone number? Why did she ask what's your phone number? No email record. And with that, she never did anything on the ACA again. I don't think she should have recused. She walled herself off from Obamacare on the very first day. She had nothing to do with it. The better question that no one asked her is, why did you wall yourself off? She knew she was getting picked. She knew she was next up. Sotomayor was first. She'd be the next one when Justice Stevens retired. So she was basically guarding herself so she would not have to recuse from the Obamacare case. There's so much moving parts here, my friends. You read these opinions, you think that they're simple. There's a lot. Never forget, judges are human. Judges are humans. They're not these oracles in the sky, right? They're actually humans with personalities and ambitions and egos. And you can see the egos flying in this case, particularly with the Roberts and Sotomayor back and forth. But they're humans. And they generally get along, but once in a while, their personal blah spills into the opinions. And I think the Sotomayor opinion is a very good example where it's like bad blood. This is personal, right? This is not like an academic dispute over like diversity jurisdiction. This is real meaty stuff. So Sotomayor's hand up. Yeah, the Roberts quote was very, how do you put it, polarizing, in that he's being cited over and over again against him. So let's walk through the Sotomayor dissent. Jay, I think yours. So Jay, walk me through Sotomayor's dissent. What was her sentiment concerning the reality of this approach?
She talked about that the democratic process in and of itself should provide sufficient protection against the effect of minorities. So because of that, that's kind of the whole reason why the laws are in place.
Yeah, she makes like a historical point, right? Her historical point is that this amendment was ratified specifically because the states could not be trusted to structure their political process in a way to protect all people, right? That's why the states structured this process. I'm sorry, that's why the 14th Amendment was ratified. And she even looks at the history in Michigan in particular, right? Where over these decades, gradually certain progresses were made with respect to racial integration and racial equality. And indeed, in 2003, the Supreme Court upheld Michigan's effort to do exactly that with the Grutter decision. Right? Don't forget, she says, Grutter specifically upheld the fact that you could use race, if narrowly tailored, to achieve these compelling interests of diversity. And she says the boards of regents at Michigan State and told us that they can achieve the benefits of a diverse student body without implementing these race-sensitive plans. She says at the very end, to be clear, I don't mean to suggest that the virtues of adopting race-sensitive admission policy should inform the legal question before us, but I can't ignore the outcome of the decision. Because the exact outcome of this decision is it puts them in a pre-Grutter state, where they can't use this exact policy that the Supreme Court had already blessed. Okay. Any other questions on the Sotomayor dissent? It's long, but I like assigning because there's a lot of stuff in there. Again, if you read it as the Fisher dissent, it actually makes a little bit more sense, but the sentiment's much the same. Anything else? Yes, ma'am.
People say like, oh, in order to prevent racism, stop talking about it. And I think that's kind of what the whole, discrimination based on race, not discrimination based on race. Like, I don't think it works like this. You can't wish it away. You can't, just because you don't talk about it doesn't mean it's not happening. People are being discriminated on their race. Everything you have to actively do. It's not to actively work on preventing this kind of discrimination with education or jobs or anything. Like, there's no way to wish it away. I think that's what people want to do. I think she's right. There needs to be a discussion. Openly, bluntly, candidly, not that, this person everything over 25 years off of the way.
Yeah, and she's responding directly to the chief. There's no doubt about who she's talking to. She's talking right to Roberts, exactly. Anything else in the dissent, Professor Sotomayor? Sam.
I really found it interesting that this whole section matters and all the reasons why race matters. I thought it was very good. I mean, it was very emotional, actually, I thought. But I'm wondering what, is she just responding to the fact that they're saying they're hoping, like, past cases are hoping that race shouldn't matter, and she's saying that's kind of not a possibility? Is that what she's saying?
I think her point is that it's not enough merely to maintain the status quo and do nothing. That because race does matter, affirmative action, which is the actual name itself, you must do some stuff. And specifically in this context, by enacting this amendment, you've made it that this is no longer a subject of political discourse, right? This is no longer something that voters can discuss when they're voting for the members of these, trustees. So imagine you were voting for these 5-member boards, and there was a debate among them. And one of the questions the moderator asks is, what do you think of affirmative action, right? That is an opportunity where these 5 members could have debated this topic. Now the amendment removes from their opportunity the chance to even talk about that question. So the only way to even revisit this decision would be through another constitutional amendment. All right, anything else in the dissent? Okay. All right. And then, again, Roberts, who his fairly brief opinion, he almost never writes separately. So I think as some of you picked up, he took this one, I think, quite personally. And he says that it's not out of touch with reality to conclude that racial preferences may themselves have the debilitating effect of reinforcing precisely that doubt. And if so, that the preferences do more harm than good. This is akin to Justice Thomas's dissent in Grutter, that there's actually a cost inflicted by these affirmative action policies, and that people should have the power to minimize these. And Schuette writes, to disagree with the dissent's view is not to wish away, rather than to confront racial equality. And the last part, people can disagree in good faith on this issue, but it similarly does more harm than good to question the openness and candor of those on the other side of the debate. So this is his direct response to Sotomayor saying, If you charge me with bad faith and you say I'm simply being ignorant, that itself limits the debate. So this is a rare instance where the chief actually spills onto the page his personal thoughts. He's usually very circumscribed. And he very rarely, if you ever watch him at the State of the Union, he sets up like a potted plant. He's like this, like he's very straight, right? He very rarely shows his emotions. And I think here it came out. Jamie?
As we're trying to learn the personalities of the justices and like how they would weigh in favor of certain issues like this, would you say that Scalia and Roberts aren't not ignorant, but more of just idealists? Because to say the Constitution is colorblind, that's not true for American citizens. We'll never be colorblind. I mean, that's very idealistic to hope for.
It's hard to answer questions. I don't like psychoanalyzing the justices because I'm not qualified. I've met them, but I don't know. They're not friends. I don't count them as good friends. What I'll respond though is I think it's a different worldview of what the Constitution actually means. And if you take your starting point that the Constitution prohibits racial classifications, period, then the consequences of that mean courts are not entitled to intervene one way or intervene the other way, that the judicial inquiry is fairly limited. If you take the position that the Constitution is not colorblind, that you can consider race for benefits, as the dissent does, then you take a different pact. One thing I'll note, and I saw at the end of reading the Freedman's Bureau Act, which I did very deliberately, neither Scalia nor Thomas has ever attempted an originalist understanding of affirmative action. And there is pretty decent evidence that at the time of Reconstruction, there were race-conscious measures to help the freedmen out. They existed. I gave you the Freedman's Bureau Act. Perhaps one distinction is, well, those were after the Civil War. It's very urgent, and there was an urgent need. But there hasn't been a strong originalist case that Justice Harlan was right. And Harlan wrote in Plessy that the Constitution is colorblind, and that's where it stems from. But it's not self-evident that Harlan was right. Of course, Harlan wrote that in a Plessy dissent where he was one justice alone. So that's a dissent we usually celebrate. So I really resist psychoanalyzing justices. I as a personal matter, I don't like doing it. But I do think it's based on their first principles of how they read the Constitution and the 14th Amendment. So,
could you also look at this case as like horizontal separation of powers?
Whoa, horizontal separation of powers. What do you mean? What do you mean?
So between like the different branches of government. Sorry, meaning like judicial and legislative. Well, between the states.
I'm not sure what you, but they upheld it though. They upheld the amendment.
Oh, okay.
But
No, but like debating whether like it's an issue that comes up within.
I'm not sure I understand your point. I'm sorry.
Oh, sorry. Okay. Basically saying that the courts can't take states' powers.
Oh, I see what you're saying. So this I think was actually Justice Kennedy's point, and Justice Breyer to a lesser extent. They were very concerned with the fact that courts, if they apply strict scrutiny, would now intervene on decisions affecting matters of public concern. And unless they found there was actually a legitimate purpose within the policy, right? They didn't want courts getting in the way. I think did that answer your question? Okay. Sorry, I didn't get the first go around. Anything else on Schuette? No? All right, let's move on to Fisher then. So again, Fisher is a two-parter. We call this a SCOTUS repeater because the Supreme Court has this funny habit that when they accept a case once, they're far more likely to accept it a second go-round. So I'll summarize for you Fisher 1, which again I didn't assign because it's largely obviated. Also, I think Sergio told us everything about it last class, so you don't need to know about it. But Fisher 1 was decided in 2013. And it was a 7-1 decision. Again, Kagan was recused. And the majority considered the admission policy of the University of Texas at Austin. I'm sorry, Aggies, they didn't consider the A&M policy. They didn't consider the Texas Tech policy or any other schools. This was only about UT. How many people went to UT here, Boston? Oh wow, it's going like this. Look at that. Okay. Oh man, still too soon, right? Okay. So all right, so a fair number of UT undergrads. The history of this, as Sergio again told us, stems from 1996 and a decision called Hopwood, where the Fifth Circuit, in a fragmented en banc decision, ruled that race could never be used for an affirmative action program for the university. In response to this policy, Texas legislatures enacted the Top 10% Plan. And as you know more than law students in other states, perhaps it looks facially neutral, but it's not. It works on the presumption that Texas schools are very balkanized in terms of race, and you have some schools that are predominantly African-American, and some high schools are predominantly Hispanic, and you know if you take top 10% from this school, you'll get predominantly African-American applicants. Although curiously, this came up in Justice Alito's dissent, there was a concern that if you were an African-American student at an affluent high school in Dallas, right, you wouldn't be getting in. That actually came up in the lower court litigation, didn't come back up in the higher court litigation. So for some years, UT used only this top 10% plan because they were barred under Hopwood from considering race. Then in 2003, Grutter happened. Grutter effectively overruled Hopwood. Sergio, am I right about that? Oh, come on, man. Grutter basically overruled Hopwood, right? Thank you, sir. He's my validator, fact checker, right? So Grutter basically overruled Hopwood, and at that moment, the president of UT got in powers, jumped, right? You saw that quote. He leapt at it, right? He was like, we need to bring back these policies. And there was a process they went through, and they developed this new this new problem. I'll go through the actual process while I do Fisher 2, but I want to go through the posture. The court's decision in Fisher 1 was fairly narrow. They basically said, first, the school needs to be more specific in how they define their compelling interest. They tell us you need a critical mass. What is that? You gotta be more precise. So this, in fact, went beyond Grutter. Grutter just said a critical mass is sufficient. So Fisher 1 said, you got to give us more, right? A little bit weird. And in terms of narrow tailoring, the court said, we're not just going to take your word for it, right? You have to show us that this is the most narrowly tailored way that you can achieve these compelling interests of diversity, right? We're not going to simply take your word and say, this is the best we can do. We're going to actually demand you show us other things that won't work. So the outcome in Fisher was a 7-1 remand, saying that the Fifth Circuit must consider this under the strict scrutiny standard. Justice Scalia concurred. He said he would overrule Grutter in its entirety, but because he agreed with the remand, he voted with it. Justice Thomas wrote a very lengthy, it was a concurring opinion, may as well have been a dissent, but a very lengthy concurring opinion. And if you are upset by Chief Justice Roberts' opinion in Parents Involved, this will really make you upset. He walked through systematically the decision to use affirmative action is no different than the decision to segregate in Brown. And I'll go read if you have some time, but he walked through this in very specific detail, that the motivations for race-based classifications are no different when it's used for good or bad. And this is a debate that he had in Grutter, but he does it in far more depth. Justice Ginsburg dissented in Fisher 1. And again, where was Justice Sotomayor? If you believe the reporting, which I think is pretty good, she went along with it to avoid releasing her dissent, right? Her shooty dissent came out a year later, should have been in Fisher, but she held on to it for then. And Ginsburg says, as she did in Grutter, we should be proud that UT is candid about what they're doing. They're achieving diversity after a practice developed by Harvard that was approved by Powell and Bakke. There's no quota. With respect to the top 10%, Ginsburg says only an ostrich can consider supposedly neutral alternatives as race unconscious. 10% is premised on race, she said. Ginsburg writes that schools in Texas are de facto segregated. Remember this de facto de jure thing? They're de facto segregated. It's designed for race consciousness. she would let the judgment stand because race is but a factor of a factor of a factor. Okay, so that was Fisher 1 in 2013. It was sent back down to the Fifth Circuit. And the Fifth Circuit did not what I expected. What I expected at the time, and I was following this case pretty closely, is that the Fifth Circuit would remand to the district court back in Austin and have more fact-finding. Just find what is a critical mass? Are there other alternatives, right? Develop a factual record that wasn't present here. Instead, the Fifth Circuit thumbed their nose at the Supreme Court. This was their gamble, which actually worked. They said, all right, we'll apply strict scrutiny. The result's the same. Now, if anyone read Fisher 1, and I encourage you to read it, Fisher 1 is like saying, okay, you guys, we're not going to reverse you, but we want you to fix up this mess. Go strike down this policy so we don't have to. That's exactly what Fisher 1 was. Go strike down this policy, apply strict scrutiny. Instead, the Fifth Circuit called their bluff. And they said, no, this satisfies strict scrutiny. This will be upheld. Okay. So the case went back up. And by this time, there was a question of mootness. We don't discuss mootness anymore, but young Abby Fisher had graduated. She graduated from UT. I'm sorry, she went to LSU. That, what was that?
Not UT.
Oh, no, she went to LSU. What was that? I'm sorry? So Fisher had graduated from LSU. She had gone to Sugar Land High School. And actually, when I taught a couple years ago, one of my students sat right over there. Funny, I know where students sit in the classroom. If I see you outside of class, I may not know you, but I know you with your seat. It's a weird thing. So she sat right over there. And she went to a high school at Sugar Land. But the point, she had already graduated. So why was this case still live? You know the answer? You want to know the answer? Why was it? Yeah.
I thought she said because not guardian UT.
No, that wasn't the answer. Why was her case still live in court? Why was it not dismissed? Anyone know? Oh, what a good answer. It's wrong. No. Beautiful. But not the right answer. Yeah.
It's just that they already said it wasn't something just affecting her.
No. What's the injury that she was claiming? Does anyone have an entitlement to be admitted? The admission fee. Whatever it is, $100, whatever it is, right? Whatever it is, $70, right? Her admission fee was her injury. So again, this is actually Lauren's question. She wasn't demanding to be admitted to UT. In fact, she already graduated by that point. So she had her bachelor's degree, right? And so again, another one. But she was actually saying, I want my application fee back because I did not get a proper admission process because of this race-based program. So this is real inside baseball, my friends. There was a movement by the Texas Attorney General to moot the case. How? Give the girl a refund. Refund the money and let this case go away. But UT did not want to do this. They wanted to defend their program in court. It was a gamble. In fact, UT did not rely on the Texas Attorney General to defend their program. They hired private counsel at Latham and Watkins at a pretty high cost. Again, that bluff worked, right? Because they got the decision they wanted. Sergio, tell us.
The irony about Ms. Fisher is that after she went to LSU, she moved to Austin. She currently works in Austin. So
Yeah.
probably she was obsessed with living in Austin.
Maybe Austin's a nice town, right? So those are the facts, right? So the case probably could have been tossed on mootness grounds. In fact, there are a lot of discussions that why is this case waiting around? They can just dump it and say she graduated. But Isaac and Samuel mentioned voluntary cessation. As a member of the police department, you must know what voluntary cessation is, don't you? Tell me what voluntary cessation is.
Normally, you require a case of controversy to continue, and the case becomes moot if you take care of what the problem is. In certain cases, they will, even if it has become moot, will keep it alive because you could do it again at any time.
Okay, so let's take an example, because Isaac is a member of the Houston PD, involving police department. So say there's a police department which has a practice of brutality, right? And say that a lot of their cops are engaging in brutality. And the sheriff says to the court, Your Honor, dismiss this case because we've changed our policy, we've changed our hearts, we will not engage in this anymore. And the judge says, yeah, right. This case, and wait and see if you actually stop this policy of brutality, right? The idea is even if you voluntarily stop, you voluntarily cease an illegal action, courts can maintain jurisdiction. This is actually very, very, very relevant now with respect to the travel ban. Because even though an old travel ban was withdrawn and a new travel ban was entered, the litigants say, we still think you'll do the same thing. We still think the government will discriminate in the same way. So this voluntary cessation doctrine is a means for courts to maintain cases even after they are no longer live. A close relative of this, I'll mention this before I went to the case, is the capable of repetition yet evading review standard. Sounds crazy, right? What is this? Abortion. A pregnancy lasts no more than 9 months. I don't, maybe for an elephant, I think it's 18 months, but for humans, 9 months is gestation, right? 9 months is gestation, maximum, right? Maybe 10 months, I don't know. To take a case to the Supreme Court, takes more than 9 months. So imagine if one of the abortion cases, you said you filed this complaint, and by the time you get to court, either the child came to term, child was born. The case is moved, throw it away, right? So the court developed this doctrine known as capable of repetition yet evading review, where the sort of constitutional injury you claim is limited in time, and it will never get as far as you need to go before the case is over. But there will be some other woman who has the same condition later and the same this and that, right? So courts have a lot of discretion with jurisdiction. You don't really study jurisdiction in law school. At least take Fed courts. But courts have ways of keeping cases alive, horrible choice of words, but keeping cases active even if the injury itself is gone. Make sense? I think an elephant is an 18-month gestation period. I don't know why I know that, but I read that recently. So yeah, it's true. I think humans are the only animal that gives birth to something that can't walk right away. It's a fairly unique aspect of humanhood. Anyway, I'm reading a book on evolutionary biology. Sorry, I channel what I'm reading. Okay, what else? Any other questions on Fisher 1, which you didn't read, but Sergio, anything on Fisher 1 I'm missing? I got it all? Yeah, thank you, sir. Oh yeah, Brian.
I know they talked about the fact that she didn't actually have grades.
Well, so this is a point that came up at length, and it was actually legally irrelevant, right? Whether or not she would have gotten in with the grade she had makes for a nice meme, right? Abby with the bad grades, right? It makes for a very nice meme, but it's factually irrelevant because her complaint wasn't that she would have gotten in, but that she wasn't given a proper admission process. So yeah, I mean, this was like the big thing last year. Her grades were bad. She was outside the top 10% Sugarland, which I think is a fairly well-to-do high school. I mean, I'm not from here, but apparently it's a fairly well-to-do high school. And but she did not make the cut. I think it's actually 8 or 9% now. It's not even 10, whatever it fluctuates.
Why didn't she go after the 10%, the top 10% and try to like?
Why did or did she not?
Yeah, I think she tried to get rid of that.
This case was stretching for like 6 or 7 years, and it was very complicated. In fact, there were originally two plaintiffs. One of them dropped out. Anyone want to guess why she dropped out the second plaintiff? Well, she didn't get to UT. That's why she sued.
Wasn't it because she just said, like, screw it?
No, she had a very distinct reason. A reason that all of you appreciate.
Did she like go to a junior college and transfer?
What kind of school? Law school. The number 2 plaintiff went to SMU Law School. For reasons I'm sure you'll appreciate. She did not want to be a Supreme Court plaintiff while she was in law school, so she dropped out. It's true. The things not in the case, but she went to SMU Law School. She probably graduated by now. This was a couple years ago. Abby, I think, was 5 or 6 years younger than me, so she's probably already out. But anyway, by the way, and I say this not lightly, but Ed Bloom, who organized this case, is currently looking to file it again, and he's looking for more plaintiffs. He is. He is the same guy who brought suits at Harvard and UNC, alleging that their systems are discriminatory against Asians. So that's the new strategy. Actually finding people with adequate grades who would have gotten in, but for this. This is the new approach. So Ed Bloom is currently looking for new plaintiffs. This is it'll be filed probably the next year or so. So stay tuned. There'll be Fisher, it won't be Fisher, but it'll be someone else also challenging the UT's program. They're not letting this one go, right? This is not quite over yet. All right. So Fisher 2, again, it was argued in October of 2015 when Justice Scalia was alive. And if you listen to the oral arguments, which I encourage you to do, I can say with absolute certainty that Justice Scalia would have voted to strike down this policy. How do I know this? He already told us. In Fisher 1, he said that he would overturn Grutter. There's no doubt in my mind how this vote would have shaked out. So again, Kagan was recused, and you were down to 8 justices. Do your hand up? Okay, I'll give you a second. Kagan was recused, was down to 8. So the best case scenario with those votes would be to simply 4-4 affirm. And what is the consequence of a 4-4 affirm? The judgment of the lower court stands, but no new precedent set. In other words, UT could have kept their policy, but you could have just challenged the same exact thing next year when another justice was confirmed. Of course, in hindsight, it would take more than a year for another justice to be confirmed, so that would have been probably tough. Shakaran?
Yeah, that's what I was gonna say, like, wouldn't it really matter, right? I think later on in order to actually challenge the
We didn't know that at the time.
Right.
But that's why Ed Bloom is bringing another one. The guy who organized Fisher is bringing a new round of cases. He's basically looking now for people who were applying to UT and rejected. And they're like freshmen now. That way they can go 4 years and still have something to complain about. But they're recruiting new plaintiffs. All right. So the beginning of Fisher 2 is somewhat ominous. This court is asked once again to consider whether this race-conscious admissions program is lawful under the Equal Protection Clause. So they walk through the admissions process, and they actually do a pretty good job of explaining how race is actually used. Are you next?
Yeah.
Oh, look at that. Okay, go for it. So how exactly does race factor into the application process at UT?
Well, I mean, they.
You're an Aggie, right?
Yeah.
Okay, so try and be generous, be charitable.
Well, they state that like with race, like I just said, like the segregation allows for top 10% to.
Oh no, but where in the application process does race actually fit in? Let's look at the actual process itself.
In the holistic process review.
Okay, Brian, a little bit more, maybe.
They have the PAI.
Okay, that's what I wanted. Yeah, tell me about the PAI.
Yeah, it's so it's it like gives it's based on like the essays, and it gives the applicants a number, and then they say that it's given weight as a sub factor of that, which is already a factor.
All right, good. So the formula is actually far more complicated than is worth explaining. But the point to stress here is that there's a category called special circumstances, right? Or special conditions. I'm sorry, no, special circumstances, was right the first time. That considers a number of different issues, such as socioeconomic status, the family responsibilities, single family homes, SAT scores, language spoken at home, and then finally race. So race is used as one of the possible special circumstances. And the special circumstance is one of various factors that go into it. That's actually what they mean by factor of factor of factor. And the cutoff points, right, once you add up all these scores, are determined by people who don't see the race. So they make the cutoff, right, if you have like 40 points, whatever the number is, right, you're admitted. So people can be admitted without actually considering which of these factors is dispositive. This is not like at Gratz where 20 points for being Hispanic, right, 20 points for being African American. It wasn't like that. Justice Alito's dissent raises a point the majority ignores, that the race of a person is listed on the cover page of the application. And Alito says that every decision, every scoring decision they make is done with that. So even though race is but one factor, Alito suspects, without any evidence, that each subsequent decision is informed by that. Now, why do I say without any evidence? The university was steadfast in the refusal to explain how this actually works. There were depositions and everything else, and nothing comes out of it. So it's not really clear how these numbers are assigned and to what extent the race factor actually impacts the other numbers. Ultimately, the court doesn't really care about this because they defer, right? They defer to the judgment of the university. But this is the primary contention of Alito, that this deference is not appropriate under strict scrutiny. Okay. So Fisher 1 was remanded because the Fifth Circuit applied a good faith standard. Fisher 1 said, no, apply strict scrutiny. Okay. So, I can't see your name tag. Griffin, sorry. Oh, there it is. I was behind her head. There it is. No, that's worse. That's worse. Thank you. Griffin, how does the court in Fisher 2 understand its opinion in Fisher 1?
They break down her 4 arguments. They were doing Fisher 2. Is that what you want me to start with?
Well, I was talking about the level of scrutiny, but we can get to the 4 arguments later. Well, how did the Fisher 2 court understand their own opinion? By the way, this is Kennedy too. It's basically Kennedy on Kennedy.
Well, I just said that the Court of Appeals didn't take that into account. They just good faith standard.
Right. So the analysis here, the court says that the UT program is sui generis. John, you know what that means? Sui generis?
Yeah.
Why is the UT program unlike any other?
Because it took it considers the top 10% and the holistic background and stuff like that.
Right. So what goes the significance of Kennedy saying that UT's program is sui generis? What's the significance there in terms of precedent?
Yeah, I guess there's no perfect precedent to follow.
No. What about other schools looking to Fisher?
Yeah, what it said,
So this is why Kennedy drives lawsuits batty, right? He always puts this wiggle room into his opinions that make it indecipherable. By saying that UT is sui generis, this raises the possibility that some other school can say, well, we're different. We don't have this top 10%, so we have to have a different analysis. This is why Kennedy drives everyone nuts. But he says, indeed, it's sui generis because you have this combination of the 10% plan and the holistic approach. So let's now walk through the 4 arguments I think Griffin mentioned a minute ago. Brian, Fisher argued that the school never defined what a critical mass of diversity is. How does Kennedy react to this claim?
Pretty much he said that obtaining a critical mass did not constitute a goal that can be or should be reduced to pure numbers.
So here is the conundrum of the critical mass, right? And let me see if I can walk you through this cleanly. We know from Bakke that you can't have a quota. You can't have a set number. We want this number of people in the program, right? That's unconstitutional. Yet, the university says, we don't have a critical mass yet of educational benefits from diversity. So here's a dilemma. There's a number, right? Whatever that number is. But there's some number of minority students that will give you these benefits. But you can't have a number because that violates Bakke. So here was the trap, right? In Fisher 1, the court said, you need to specify with clarity, sufficient clarity, what a critical mass is. And the university says, no, we don't. We'll never do it. We don't know what that is. Why? Because once you set that level and you reach it, then you can't use affirmative action anymore. That's why they won't say it. But that's not what they tell the court. So Kennedy says, well, you can't give a number. So we will more or less defer to the university's judgment. If you've heard the phrase, you know it when you see it, trust us. But it can't be illusory or amorphous. They must be, quote, sufficiently measurable to permit judicial scrutiny. So again, how can something be non-quantifiable but judicially measurable? The end result of Kennedy's analysis is, trust us. Whatever the university says, that will be the answer, and they'll tell us when you hit a critical mass. And my suspicion is that number will never be reached, right? They'll always find, you can always do better. Okay? So even though in Fisher 1 they said you need to define the critical mass with sufficient clarity, nothing changed in Fisher 2, yet it suddenly became acceptable. This case confounds. I did an event in DC in June with the guy who actually argued Fisher 2. And a guy named Will Consovoy, he went to my law school. I said, Will, what happened? He's like, I don't know, right? You had one test in Fisher 1, and then Kennedy, and then something changed Fisher 2. So there's a little bit of a moving target. Okay. And then they go on discussing the top 10% plan, but the primary point there is they say it's not adequate to achieve the results. What results? Critical mass. What's that critical mass? We'll trust you on it. So everything boils down from there. Once you accept the university's representation that will tell you we have a critical mass, then the judicial role is basically saying, okay, we believe you. The one place where the judicial role actually exists, though, concerns whether it's narrowly tailored, right? Are they using the least restrictive means to achieve this goal? And here again, there's not much scrutiny because the university refuses to tell them exactly what they're doing. And you can go through the record. They obfuscate at every angle. These people are highly trained, but they can't tell you what they're trained in, right? It's the damnedest thing. But Kennedy says, that's adequate. We will trust you on it. So the majority opinion is actually fairly straightforward in the sense that it gives a different test than they gave 3 years earlier. And unsurprisingly, the school meets that test. So the UT policy was advanced. All right, any questions on the majority? And again, it's not a majority. It's only 4 votes. They're not 5 votes. So any question on the Kennedy opinion? I'll call it the Kennedy opinion. Yes, sir.
So what was the reasoning, I guess, why so much deference was given?
So this is, you're asking inside baseball, right? Kennedy probably changed his mind. Maybe persuaded by Sotomayor, maybe otherwise, who knows, right? But the point is, the standard in Fisher 1 was not the standard in Fisher 2. Maybe Kennedy didn't want a 4-4 affirmance. Maybe he could have said, I mean, what the court could have done is simply re-argue the case the following year. They could have done that. But I think he said he wanted to uphold this policy, and maybe he changed his mind. I don't have a much better answer. So I told you, I saw Will, the guy who argued Fisher. I'm like, Will, what the heck happened? And he's like, Kennedy. It's basically that. Anything else on the the Kennedy opinion? It's not a majority opinion. Alex.
I just wanted to ask, what was the phrase you used? You said the dilemma here is how can something be constitutionally measurable but not
quantifiable, right? You can't quantify the critical mass, but instead it's tested, you have to be able to measure it for a purpose of judicial review, right? How can you measure something that you can't quantify? So it's this weird conundrum, right? If you take from the starting point that you have to create a critical mass, that is a number, that is a percentage, that is something. But the second you have that number, it's unconstitutional under Bakke. So it's this weird loop. There's no answer to it. And this baffled oral arguments last year when the university lawyer said, well, we'll know it when we see it, right? We'll tell you when we get to a critical mass. We don't know what that number is. It's not an actual number, but when we get there, we'll know. Because I mean, you're actually admitting people. These are human beings, and they're, there's a number that. So the admission people probably have a number in mind. They'll just never tell the courts. Maybe it's based on the population of the state, so that the student body resembles the state they're in. But once you say that to the court, you have a quota, and they can't say that. But I suspect they're trying to mirror the population of the state, but not for Asians, as Justice Alito points out, because they're vastly underrepresented, but given no preferential treatment. Okay, this is why Ed Bloom's next case is with Asian kids. All right, anything else on the Kennedy opinion? Justice Alito's dissent, joined by the Chief and Justice Thomas, again, Scalia was not here anymore, says, something strange has happened since our prior decision in this case. In that decision, we held that strict scrutiny requires UT to show that its use of race serves compelling interests and that it's narrowly tailored. Right? Alito continues, the university has still not identified with any degree of specificity the interests that its use of race and ethnicity is supposed to serve. Its primary argument is merely invoking, quote, the educational benefits of diversity is sufficient, and that it need not identify any metric that will allow a court to determine whether the plan is needed to serve or is actually serving those interests. This is nothing less than the plea for deference that we emphatically rejected 3 years earlier. Yet today, the court inexplicably grants that request. So Alito's dissent is more or less mirroring Thomas's dissent in Fisher 1. UT never explains what a critical mass is. They never explain if, in fact, that this was the most narrowly tailored approach possible. They never explain if other alternatives could achieve similar solutions. To use one example, one of the metrics they cite is there's a certain number of classes where you might have only 1 or 0 person who's African American or Hispanic. The school never identifies as, are the people being admitted through this holistic program more likely to go into those classes, or maybe they choose other majors and don't take those classes. That is, maybe there are factors separate from the admissions policy that decide why certain classes have certain composition, right? That's something you could prove, but the university never did it. Why? Alito suggests because they wouldn't like the results. And they don't actually want to prove whether this policy is effective. And he quotes from the president of UT, Bill Powers, who I think had to resign 2 or 3 years ago after scandals, people nodding their heads. And Bill Powers said, opponents accuse defenders of race-conscious admissions of being in favor of social engineering, to which I believe we should reply, guilty as charged. So Alito's point is that these affirmative action policies aren't actually geared at any end game. It's merely achieving the racial balance that the court said in Bakke you can't do. And all this other obfuscation, Alito says, is a smokescreen. Alito writes, this cannot survive the rigid scrutiny. Trust us does not work under strict scrutiny. That you have to have some sort of judicial inquiry that is not being met here. And if you notice, he keeps citing Kennedy. He cites Kennedy in Fisher 1. He cites Kennedy in Parents Involved. He keeps citing Kennedy, saying, come on, Tony, you said this 2 years ago. What gives? But if you notice, Kennedy never bothers responding to dissent. He doesn't do that. That's not his thing. And at bottom, the policy was upheld. And this was a very unexpected decision, because if you listen to the arguments, it looked like this was not going to stand. Alito concludes, this conclusion is remarkable and remarkably wrong. And those are fairly strong words for a dissent. So this topic, I keep saying bad blood, I'm sorry, let's listen to a Taylor Swift album the other day. There was a lot of animosity going on here, because this was going on for like 3 or 4 years, a single case. So this case is gone. If Ed Bloom finds his plaintiff, another case will be brought back. All right, questions on Fisher 2? Jason?
When I was reading the Alito dissent, I was kind of thinking to myself, this seemed a little more intense than some of the other dissents.
Oh yeah, you could feel it, right?
And it kind of brought to question, because it seemed like some of the facts that they were providing in this dissent versus the majority seemed a little conflicting to me. So I wasn't sure if there was any twisting involved in there. Like, to me, the fact that UT in the Fisher 1 case had made the comment about, well, this top 10% rule brings in, there's these poor black people, but we want the Dallas black person, like we want the professional person. That seems pretty damning to me. If their whole idea is they're trying to get this, they're selecting based on race, but then they're saying, oh, no, you're not the right one.
So to grossly oversimplify, UT changes positions many times. This case went on literally for, I think, 5 or 6 years. UT changed their answer at each juncture depending what arguments were in the court before them, right? And part of it is not necessarily their fault. If you have a judicial decision and the judge says one thing, you can then shift your arguments conform to what the precedent is. But the facts, they changed their facts. And at various junctures, UT said that the top 10% plan was adequate. And they dropped that once they said they could now do Grutter. So the facts in this case are very messy, which is why I think they're starting from scratch. Also, and this is an important point, there was never a remand to the district court. The factual record in this case was never supplemented after the first Supreme Court decision. What the Fifth Circuit should have done was simply send it back to the district court in Austin and say, okay, try this again. But instead they kept the same record, which is why I think Alito was very upset. He was not happy with this decision. You want to go again? Anyone else before I get back to him? All right, go again.
The other question I had, just from, I guess, an argument standpoint. So one of the arguments that Fisher brought up was that they should just enact a wide 100% top 10% policy.
Like a 20% policy, whatever, right?
I don't remember what the percentages broke down to, but in my mind, that seemed kind of stupid, just given that she didn't make the top 10%. So why in the heck would she argue?
Well, I think what Alito says is you uncap it and then you go to top 20%. If you're not getting enough minority applicants with 10, make it 20.
Oh, okay.
That's what I mean by uncap. 25, 30, right? In other words, UT would not need to even accept people through the regular admission process. Maybe a small number of people, maybe 5% of the admission process. And this goes back to a point Thomas made. UT has no state compelling interest in having an elite university. You notice this wasn't an A&M case. No offense, A&M, right? This was the flagship school of the state, and they want to have elite grades to be comparable to, like, you know, Harvard and Yale. And Alito says there's no obligation to have an elite program. If they want to admit more minority students, they can drop the credentials, like Harvard did apparently. Jens.
Like I forgot who mentioned it earlier, but like the stats that the UT provided, how much do you think that went into like swaying the argument their way, like using statistical analysis of like over like once we change this, it increased like 94% or something like that?
So look, this is the question of deference, right? And the majority opinion in Fisher 1 said, we're not going to believe this. Go back and give us more actual facts. And then in Fisher 2, they said, okay, the same exact facts. So the first time, wow, they satisfy strict scrutiny now, right? Usually nothing satisfies strict scrutiny, nothing.
So those facts were in the first?
The record was exactly the same, which is why this case is so damning. The exact same record from Fisher 1 to Fisher 2, there was no new evidence submitted. Questions on Kennedy or Alito? Right, so let me summarize and I'll let you guys out in a minute. The topic of the 14th Amendment and racial classifications have been, needless to say, among the most divisive in the court's history. And I think what you found is not much clarity, right? The court has upheld the use of affirmative action in this context, but even Justice Kennedy's opinion says it's sui generis, which leaves open the possibility that perhaps another state, which does not have the 10% plan, would not be upheld in the same context. But I think the most important part of this case is deference. And so long as the courts defer to the school about if and when it reaches that critical mass, the role of the court is minimal. And whether in fact that's strict scrutiny, as we've traditionally understood it, is a different question altogether. But there seems now to be a special carve out to strict scrutiny for affirmative action that doesn't really fit in with anything else we have. When we get back from the break, we'll be doing gender discrimination and other types, which have been equally nebulous, have been all over the place. But the racial classifications are among the most contested in the court's cases. Anything else? Enjoy your spring break. I'll see you when you get back.